May I please invite Dr. T.N. Ravishankar sir to chair the next session, and Dr. Jayashree Srinivasan, ma'am. Okay. Dr. T.N. Ravishankar sir is a product of the prestigious Madras Medical College, where he completed his undergraduate in medicine and has been a family practitioner for 3 decades and has been managing a 100-bed chain of hospital for 25 years. He was an active IMA Tamil Nadu and headquarters and has occupied several posts with distinctions. He has been a faculty for the Anna Institute of Management, Government of Tamil Nadu, and for several medical colleges for medico-legal topics. He is a recipient of Best Doctor Award from the Dr. MGR Medical University and Doctor's Day Award from Government of Tamil Nadu.
I request Dr. Jayashree ma'am, HOD Obstetric and Gynecology, Savitha Medical College, to chair the session.
Good evening to all of you. Let me thank A4 for giving me this opportunity and also to introduce a dual personality, Dr. Hitesh Bhatt. May I request him to come on to the stage, please. A medical practitioner, obstetrician, who has mutated into a advocate, practicing at Andheri, Mumbai. He is a medical legal consultant for more than 2 decades. And is a partner in the legal firm BNS Medico Legal Consultancy. He has authored books on medico legal as well as in obstetrics and gynecology. The most important thing that in obstetrics and gynecology is that concern. I think whatever we saw a little bit earlier, that also needs to have a concern before we do the procedures. A faculty and a delivered talks pan-India, running to more than 1,000 odd. And something new that what I saw now is a life member of the Film Writers Association, Mumbai. Let him also explain to us what is there in this as a film writer.
So that is the oldest. I am actually an actor writer in Bollywood. So that is it. That's nothing.
Thank you. Over to you, sir.
So
May I please invite the panelists for the session? Dr. Shivani, Dr. Ramya Karthikeyan, Dr. Shweta, Dr. Priyanka, Dr. Geeta, Dr. Mangayar Karasi.
So good afternoon, everyone. So to present anything after Dr. Osama Shoki, like that makes me feel like 8th husband of Elizabeth Taylor. You know, Elizabeth Taylor had 8 husbands. The 8th husband, on the day of marriage, he knew what to do, but he was not sure how to make it interesting. Same is my situation. But I will try my level best to make it interesting. So what we have done is a reverse panel, and reverse panel is where the panelists will ask the questions. You are also among them, and if you have any question, you can also raise your concerns. And I will try to answer the questions which they are asking on your behalf. So we can start. I chose this reverse panel because for 2 reasons. First, having knowledge of the law, studied law, practicing law, and if I am asking the questions to the doctors who have not studied or read the law, is pathetic, right? It is a torture. I should not be doing that. It is like MSc graduate is asking question to first or second standard students because they don't have any knowledge about that particular field. If they start asking me about the IVF and ART, I will be looking, or I will be in same pathetic situations. So it is better they ask the question. And second reason is, that is most important, that I am husband and I am married. So I am trained to give answers, right? So it is always better I give answer. Yes.
It will also be like cross-examining if you ask the question to them.
So you have any question? Yes.
PowerPoint. Shall I start with the first case, sir?
Yes, sure.
So there was a second gravida with a previous cesarean section. She was admitted in a private hospital for a trial of labor after getting due informed consent about the risk of a scar rupture and its impending complications. So in spite of that proper monitoring, she had a scar rupture and she was taken for emergency section, and the baby had a neurological deficit, for which the parents are sued, and for that, and the doctors have to pay 60 lakhs for the negligence. And in spite of getting a proper informed consent explaining about the risks of the threatened rupture and its impending complications like the neurological deficits to the baby, so what else can we do to safeguard ourselves?
See, when it comes to a compensation, every case is a unique case. It is not that just because there was a perforation or a scardation and the consent was taken, they lost the case. There are many aspects to it. Case is the facts. The fact is consent taken and decision happened, right? That is the fact. But it is a half truth. It is like half filled glass of water. If the opposition lawyer, he proves to the judge that the glass is half filled, he will win the case. If you can prove that it is half empty, you will win the case. So there are so many factors involved. What judgment they have produced, what evidence they have given, what authorities they have given, what type of representations they have made, and from which side of the bed the judge has risen on that day. It depends on so many factors. And it is not that you are losing a case, that means you have done something wrong. You may lose the case at the district commission. You go for appeal, you will win it at the state commission. They will go for national commission, you again lose the case. Again you go to Supreme Court, you will win the case. And it ends there. Because there is no court above. Otherwise it will keep on going for perpetuity. So there are so many factors involved. But consent is definitely something which can help you. But it should be a proper consent. Proper consent means Supreme Court has given a definition or a proper elaboration what a proper consent is in the Indian context. In the case of Samira Kohli versus Dr. Prabha Manchanda. So consent should not be blanket one. We are using the consents, only single consent, you write the name of the procedure and the consent becomes of that procedure. That is not allowed. Right. So you have to have a proper consent, as Supreme Court has said. It should be properly signed. It should be properly filled. Even in the case of Yashoda Group of Hospital, Dr. Jaipal Reddy versus Yashoda Group of Hospital, that case the National Commission said that consent is not a one-step procedure of signing, because there were the blanks were left blank. I, doctor dash, patient dash, operation dash, risk dash, everything was left blank. The court said when doctors do not have time to fill in the gaps, we have no reason to believe that this was explained to the patient. So there are many aspects to a case. So don't come to the conclusion. And last thing, even if the negligence is involved, even if you have taken consent, it can be held against you. Consent is not a license to kill. Understand that. Consent is just a document that you have told the risk. That doesn't allow you to be negligent. Right? So there are many aspects when you lose a case.
So I moved to the next case. So she's a third gravida with previous 2 cesarean sections, sir. And when she came, she told us that she has 1 boy and 1 girl. And now she just recently identified her pregnancy at 16 weeks. And she was very much insisting that we offer her termination because of her personal financial situation and all that. So we got form of consent, did a scan, and we proceeded with the MTP. But unfortunately, she had a uterine rupture the same night and we had to do a laparotomy. So all that went well, but we were insisting her to do a sterilization as well because anyway she's completed her family. But the relatives denied strongly. So post-procedure, this fetus, it was a female. And after the procedure, the attenders come and reveal to us that they actually have only 2 girls, and this time they've done a sex determination outside. So they didn't want this baby and they came for termination. So in this kind of a situation, supposing she goes on to put a case in future, what kind of documentation will protect us from all the sex determination thing? And is it okay for us to do a termination of pregnancy in the 2nd trimester when there's no real indication, no obstetric or medical indication? And can we deny a 2nd trimester abortion in case we are not convinced of the reason?
See, termination is guided in India by Medical Termination of Pregnancy Act, right? That was enacted in 1970s and 74, and then it was amended recently in 2021. So they've allowed termination up to 24 weeks now. Up to 20 weeks, the indications are same. Even failure of contraception is an indication up to 20 weeks. Between 20 to 24 weeks, there are only two indications practically. One is lethal anomaly and second is rape. These are the two indications between 20 to 24 weeks where requirement of 2 doctors' signature is there. Now, there are various things attached to it. First, Section 3 of the MTP Act says if any termination is done, a case will not be filed against a doctor or he is protected if for the IPC will not be applicable. Any Indian Penal Code will not be applicable. So that is a protection given in the law that you can use. Second thing is, as far as the sex determination is concerned, in the criminal law, there is a dictum. If you are ignorant, you are safe. But you can't pretend to be ignorant. You can't say to the patient that, okay, you have done sex determination, but I am not writing it. If you have that knowledge, then don't indulge into it. If you don't have that knowledge, if you are really ignorant, there is no problem. Courts are lenient on such issues. So if they have done something somewhere outside, it is none of your business. But if you know that, or if you have a high suspicion, suppose she has 3 abortions, she is having 2 female child, 3 abortions, 4th time she has conceived, then you have that suspicion, right? Every normal person will have that suspicion. You cannot close your eyes and say that, okay, I will do it. I don't know you have done sex determination. You should have normal diligence. That is what is expected by law, right? Anybody, the things which can be guessed by everyone has to be guessed by you. That much expectation of a diligence is there by law. So if you show that, then there is no problem. You can go ahead and do it. And in worst case scenario, like you have some doubt and patient is saying no, what you can do is, if there are no history of abortions, right? If there are history of abortions, second trimester abortion, you are definitely sure. But if you are not sure, it is just first time and you know the mentality and still you want to do, you can take affidavit from the patient. You can say that I have not done extra care. It is not required by law. But that is what I suggest. Even like there are previous 2 female and patient comes for IVF treatment, right? There are cases. So we make them sign that this is not for the sex determination, they are going ahead with the treatment. So you just see your safeguard first.
So, and supposing MTP pills are offered in some other hospital, and then the patient comes to us for the check scan, and we see that there is still a live fetus inside, and we want to proceed with further either medical or surgical management, do we still take a fresh Form C consent sign from this patient? And for post-abortal check scan, is a Form F again required?
Yeah. So, how the patient comes to you, that is more important. Like if patient is coming to you with a bleeding, patient is coming to you with some signs of abortion already done. So we are treating it as either incomplete abortion or inevitable abortion. These are not MTPs. So if it is incomplete abortion or inevitable abortion, you can go ahead and do whatever treatment you require to do. You may not fill the forms. If pills are given by somebody whom you know, like up to 9 weeks, as per MTP Act, there is a provision that person can give the pills in that hospital, and if there is a need for DNC, they can send the patient to you. So if it is done in that way, you know that MTP pills are given by a person who is RMP as per definition in the MTP Act, and he has filled all the forms, then you may not fill the form because you have given access permission to that doctor to utilize your facilities in case of need. But if they have taken MTP pills from somewhere else, you don't know whether it is MTP pills or not. In that case, if fetus is alive, it is better to fill Form C and Form 1. And you have to take it as MTP. And what indication you will take? You will take that anything which will endanger the life of the fetus, because she has taken some medicine which you may not know have some harmful effect on the fetus, right? So under that indication you can do the MTP.
And post-abortal Form F, sir, for check scan, do we?
Always. If you read Form F, that is sonography, PA, PCP and DT Form F, it is mentioned as a 6th indication in column 10, post-abortal cases. We are not filling these forms. We have to fill this form. Otherwise, the punishment is 3 years of imprisonment under MTP Act. So it is better we fill the form in such situations.
So, next case. So, the patient was admitted in labor at 40 plus 1 weeks of gestation. She was induced at 8:30 p.m. At 1:45 a.m., her pain increases and she screams in pain and wants the doctor to come to do LSCS. But the sister team there, the labor team, they have tried to conduct the delivery. And since it's not possible, by 5 a.m., the nurses decided to call the doctor as the delivery was not happening. 6 a.m., the gynecologist arrives and decides for LSCS. 6:45, LSCS was done on 14/10/2006 and the baby was shifted to NICU. Due to respiratory distress, the baby died on 23rd of October. So, should a OB-GYNEC be there 24/7 to assess the laboring women, or will trained staff nurses or duty doctors legally allowed to monitor the labor process, sir? So, in this era of natural birthing, with many natural birthing centers blooming, where exactly do we stand in midwife-led birthing? And who becomes legally responsible for any maternal or fetal complications in such cases?
See, again, there are various aspects to it. For that, we have to understand the law. Who is responsible? I'll start with the last question. It is always case-to-case basis. It is not. There is no rule of thumb. It is like a couple coming to you with infertility. Who is responsible? You don't know until and unless you run the test, right? So similarly, each case is a different case. First thing. Second thing, is doctor expected to be by the side of the patient? The answer is no, because recently we have got one judgment to that effect from the Supreme Court in Bombay Hospital versus Mr. Agrawal or Mrs. Agrawal. That case where the Supreme Court said that it is highly unreasonable demand of a patient to for the doctor to be by the side of the patient 24/7. It is impossible. So you can always delegate the work. There is a law of vicarious liability. It is said vicarious liability is liability which comes on to you when someone else does the job. Like if you ask nurse to give injection, in the eyes of law you have given the injection. So when you have asked nurse to monitor, ultimately it is you who have monitored. So if something goes wrong, you are taking a vicarious liability of your subordinate staff. So if he is a junior doctor who is qualified to do so, you can definitely delegate the duty, and courts are now, this vicarious liability is a dying dictum. It is gradually dying, its death. Previously, surgeons were responsible for even anesthetist mistakes because they were the captain of the ship. But now the law has understood that every expert or every professional is having his own expertise, right? Even anesthesia is now separate branch. At that time, anesthesia was a sub-branch of the surgery. One doctor was giving anesthesia. So now anesthesia is a specialized branch. So the anesthetist is responsible. In many cases, the court has said only anesthetist will pay the compensation. So court is appreciating this. But for junior staff, like nurse and all, there is no such law. At least you will be vicariously liable, but it is not expected from the law point of view that you be by the side of patient 24/7. But if they have made the mistake, then it will be considered as your mistake. That is the thing.
Next case. Long. Next case.
Para 2 live 2, previous 2 cesarean, concurrent sterilization was done with second cesarean. 2 years later, patient had secondary amenorrhea and she was diagnosed to be pregnant. She is 6 weeks pregnant now and is furious at the doctor and wants to sue her. How to proceed? In the event of termination of pregnancy, along with re-sterilization, can the same doctor do the repeat surgery? If the patient wants to continue the pregnancy out of her own wish, is the doctor responsible for her child's expenses? Because already a 3 lakhs compensation was charged on a doctor.
See, this individual case, again I am telling you, there are many aspects. There are many cases where court has said, even Madras High Court has said that compensation should not be given. But for that your document should speak. Like it happened with my case also. When I was practicing, I had a case where there was recanalization and patient conceived. But in my discharge card I always write, even if I used to put copper T or I used to do TL, I used to write that please come for follow-up immediately if you miss a period, right? Plus the consents and all. So if you can prove to the judge that you have said that to come to the OPD for checkup if you miss a period, that means we also had the same apprehension of pregnancy. That means we have never given any assurance of 100% guarantee that she will not conceive. Healing is a natural process. But in one of the case where Santra's case was the first case which came into limelight from Haryana, a TL failure case, where the doctor had written tubal ligation done, but on operative notes only one side of the tube was operated, as second tube was not visualized. The court said that you are negligent because you should not have issued the certificate of sterilization. You should have at least written that one tube is not visualized. So once you give wrong guarantee that you are sterilized, then it is a negligence. But if it fails in spite of having everything perfect, it is not your fault, and you will not have to give any compensation for the child unless she is your wife, right? If it is doctor's wife, it is alimony or something which you are paying, but not the compensation for the child she is raising. Also, she had opportunity to terminate that pregnancy. It is her choice to go for delivery. So you are definitely, and if you have to give compensation in such case, you have chosen a wrong lawyer.
Second case, Mrs. X has underwent lap hysterectomy. Patient presented with wound infection on 10th POD. She claims that doctor have not followed aseptic precautions during surgery. How do we defend ourselves in such scenarios?
See, any infection, there are various registers we have to maintain. It starts with the registers. See, judge will not come to see how sterile your OT is, right? So what you have to maintain is, you have to maintain a cleaning register, you have to maintain autoclave register, you also have to maintain the case paper, you also have to do various various checks, like we are sending biological efficacy tests for autoclave machine, we are sending swab tests for OTs. So all this has to be documented, plus you have given antibiotic to the patient, you have done proper dressing, and when patient is sent home, I think on 10th day patient must have been sent home. So we have to write all the instructions that if dressing is loose, come back for the dressing, don't take bath for a few days. All these instructions you should give to the patient. And if patient is found not following anything, it will be contributory negligence on the patient's part. So you have to write everything. If you write, then only there is a defense. If you don't write, there is no defense.
Thank you, sir.
So regarding fertility,
Yes.
can we do ART for a woman who is living separately from her husband without legal separation using donor sperms?
No, definitely not. You can't do that.
Okay. And what about, we have consent forms for single women and all. What about single man if he wants to have a baby?
Single man can't have. He has no option but for adoption. He can go for adoption. That's it. For single women, yes. She can, so she should be single. Single can be either divorced or widow or unmarried. There are only three, right? Staying separate is not single, right? I stay separate from my wife 25 days in a month. That doesn't make me divorced, right?
And what about post-divorce? If a couple frees embryos before they divorce, what are we supposed to do?
We are not supposed to do anything. It is like a child. If what happens to the child when they divorce? The court orders with whom the custody will go. Similarly, they can move a separate application for the custody of the embryos. If court says embryos will go to the wife, you have to deliver it to the wife. Court says it will go to man, you have to deliver to the man. Court says dispose of, you have to dispose it of. It is not your problem. Once it goes to the court, just let court order. That's it.
So regarding embryo freezing, we don't have particular years, like how many years we can freeze, especially for fertility cryopreservation. So for a few people may not turn up, or we may not be able to contact them after 5-6 years. So what are we supposed to do? For how many years we can keep it?
See, for the embryo of self and any gamete of the donor, including embryo made by the donors, 10 years. But self gamete can be preserved for more than 10 years with the national board's permission. So they have to take the permission of the national board for further extension beyond 10 years. And they can continue freezing that. If they are not paying, then it is mentioned in the particular forms like form number 10, form number 11 or form number 9 for embryo freezing, that if they don't pay, you have right to either let it perish or give it for the research purpose. That you can do.
So with respect to ultrasound, so how useful the disclaimer is and what additional points do we think we need to add in the disclaimer as the BMI of the patient keeps increasing now in the trend. So is there any universal wordings or any phrases that we need to add on the disclaimer that certain anomalies cannot be diagnosed?
Yes, we have made disclaimers for the Saimer Hospital or S. Suresh's Hospital, Mediscan Hospital or Pratima Radhakrishnan. They are all my client and we have made disclaimers for them. It is for anti-scan, growth scan, or it is for all the scans. We have made disclaimer for anomaly scan. We have made this list of disclaimers and that we print in each report and give it to the patient, because one of the claim from the patient side is that we were told that everything is normal. So I can show this to the judge that it was not told that everything is normal. So that is how the disclaimer will work. If the judge is sensible enough, he will consider it. If he is not, but if it is not printed, every judge will believe that this guarantee was given. If this is printed, some sensible judge will understand that okay, the guarantee was not given because we have put this disclaimer. Right?
So the usage of 3D was initially for diagnostic purpose. So now this has become for cosmetic and for the social media. So are we allowed as per the PCPNDT to give a picture of a 3D image face to the patients? Or is there any gestational age that we need to do? Because many patients do ask for a 3D image of the face.
Yes. See, in law and at home, one rule is fixed. The thing which is not prohibited is allowed. Right? So, if something is not prohibited, PCPNDT Act never says that don't give 3D image. There is no such restriction.
We have been to several meetings for the PCPNDT, sir, but they were very much insisting
Who they?
on. Yes, sir.
Who they?
At the PCPNDT meeting of several districts, we have it for every month. They were insisting that the 3D...
Who they but? They means who?
The JD, the joint...
So they have no right to make the law. They are there to make you follow the law. If you allow them to make the law, they will make the law. Have anybody said that, sir, where is it written in the law? Do you have daring to say that? Then you have to follow the law. You have to so in law, again, you have to learn one more principle. You can either fight or follow. You can tell him that do whatever you want to do, I will give. There is nothing which restricts me from giving 3D pictures. And definitely you will win. 100%. There is no such law. Right? But nobody has that daring. That's the thing. Then if one person is following, second is following, third is following, then he will say that when every of your colleague is doing so, why you are giving it? Right? So please raise your voice. You say that this is wrong. Only Narendra Modi and his team has right to change the law. Nobody else. It is through the parliament. It is amendment process. Then they can add this line that 3D picture should not be given. That's it. Otherwise, there is no such law.
Thank you, sir. Thank you.
That's it. So this is an area of concern. This can happen to any person sitting here. So for the audience, she was a gynecologist and we lost her recently. She had delivered a patient and the patient had a postpartum hemorrhage, which is a known complication, for which she was filed an FIR and the mob had attacked her and we had lost the woman now. So sir, is it legal to arrest a lady doctor without prior intimation, sir? And can anyone just file an FIR on doctors if the outcome is not as expected?
See, there are two systems of law, criminal law and civil law. Criminal law ends up in a jail and civil law you have to pay the compensation, right? Now for the criminal law, the Supreme Court in case of Dr. Suresh Gupta versus NCT Delhi very clearly said that doctor can be prosecuted under criminal law only if the negligence is of gross nature. It has to be gross negligence. And what is gross negligence? They have said gross negligence means something which should not happen in under any circumstances. What is that? They have said operating wrong patient, removing wrong limb, or giving wrong gases during anesthesia. Instead of O2, you are giving CO2. Or forgetting mop inside, leaving the instruments inside. So how do I conclude it as, if something is given in the textbook, it is a normal complication. And criminal case should not be filed for that. Like you show me one textbook which mentions forgetting scissor inside as a complication after hysterectomy. Have you read it? Or operating Sita instead of Gita for hysterectomy. Is it mentioned anywhere? No. But injury to bowel, injury to bladder, bleeding, infection, these are all complications given in the book. That means it is happening all over the world in spite of the best of the care. That is a simple negligence. It can be filed, it can be fought as a civil negligence. So if criminal case is filed for any such negligence, which is a simple negligence, it is very easy to get it quashed by the court. So, and here in her case, it was 302 applied. And if the sections which is applied, which is absolutely wrong, like every one of you feel that 302 is murder, right? Every one of you feel that it is not a murder, right? Then it is very easy for judge to get convinced on that point. It could have been quashed very easily. If they apply 3042, it is difficult to convince the judge because it is near to the truth. This is quite away from the truth. It is very easy to convince the judge to get it quashed.
Okay.
So she could have taken medico-legal advice. Always take medico-legal advice before taking such drastic steps, right? So always take medico-legal advice and you will get definitely a good consolation, at least on this ground. So, and we are living in India. It is such a country where Kasab, you know Kasab? He came to Mumbai on 26/11, you remember that?
Okay.
They, in 2008, right? What happened? He took the whole Mumbai in his this thing, he killed 1,200 people. There was 4,000 paged charge sheet against him, 2,000 eyewitnesses. Still it took 4 years for him to hang. So nobody is going to put you behind the bar immediately. Even if you are going to get the jail. Recently I read one case. After 35 years, one the railway officer, he was punished for 2 months jail for taking 10 rupees bribe for reservation. After 35 years. He is at 82 now.
Okay.
So if you are going to get punishment, you will get it at that age. I will make sure that you will get that age. And it is good to go in jail at that age. Don't worry. Right?
Okay, so what is the immediate step a doctor should do in case of a mob attack and steps to follow in case of unforeseen maternal mortality?
Yes. See, mob attack, I have seen videos where doctors are taking all the attacks on him without any resistance. We have, if you have strength, at least you should oppose, you have to resist, and you have right to kill the person when you have threat of your own life, right? So that section we are seeing it in movie, right? For self-defense he has done this, and that is why he is now there is no case against him. It is because there is a self-defense. It is mentioned in the law, but we never use that. If you can't do that, at least run away from the place. Jaan bachi to lakho paaye. You have to run away from the place. Save yourself first. Do not get attacked by, that is why I always tell, at least keep one extra door in your consultation room. If you feel the mob, call your colleagues. If they are coming, they are helping you. There is a mob of doctors. They will be prevented from attacking you. At least you can counter attack. You can take somebody as a hostage. You take the person as hostage. You say that if anybody will move forward, I will kill this person. You can do that also. But we are not doing anything. If you can't do anything, at least run away. Make your body that much fit that you can run away at least, right? No need to be there.
Okay, sir. So this we started doing recently, like almost all the doctors through social media, teleconsultation. Is it legal in India, sir? And can we do a phone that which is audio only, or and give a prescription, or is a video consultation must?
It's a big topic, but I will cut it short. In India, it is legal. Section 3.8 is added in Medical Council Act now. So telemedicine is legal, first thing. There can be audio, video or text consultation, but to give group A drug. What is group A drug? That is specific drug where you are making diagnosis and giving the drug. That is first drug. For that, video consultation is must. If you cannot reach to the diagnosis, do not prescribe the drug. Ask patient to come in person or ask patient to go to some doctor nearby who will give you the examination finding and then you prescribe the drug. So that way you can give. Follow-up drugs can be given on either audio or video consultation, follow-up drugs, but not the first primary drug.
Fine, sir. Okay. So, yeah, this happened to one of my friends actually. So, the doctor has prescribed a tablet Ultra-Cal, which is calcium, to a 18-week antenatal patient, and the pharmacist has given tablet Ultra-Set, which is tramadol. And the patient had taken the tablet for about 1 month. The patient developed acute severe gastritis with hematemesis, and she had gone to the nearby hospital where she found out the cause. And now she has filed a case in court of law. So is it mandatory to write generic names in prescription? And how does the law protect the doctors in such scenarios?
See, as far as generic name is concerned, they have used the word should. Doctor should prescribe. Should is in advisory form. If they wanted to make it compulsory, they will write must. But must is not used.
Okay.
So should is used. Should is advisory. It is like what your mother tells you to do. You do it, it is fine. You don't do it, it is fine. But when it is must, it is something which your wife tells you to do. You have to do it. Otherwise you are gone. So they have used the word should in the law. So no need to worry. And as far as this mistake is concerned, it is pharmacist. Even pharmacy has a rule. And that is why we have disclaimers for prescription also. Our disclaimer reads, do not give medicine if the prescription is more than 10 days old. Do not repeat the medicine. Do not change the brand. And come to show the medicine before starting. That is what is mentioned in my prescription pad. So if you write all this, if patient doesn't come, it is her fault. She has started taking it. And even pharmacist will not be having any person who is actually B-Pharm sitting there. Because one license is given to so many shops and they are running the business. That is how it is going on. So you are safe in this situation.
Okay, sir. Thank you, sir. Thank you so much.
Thank you.
Thank you so much, sir.
Thank you, sir.
Everybody will be asking about that Archana Sharma only. That's a unique case in this country where she took the decision because it was not the surgery or whatever it is. It was also involved an emotional factor, a political vendetta that was happening behind in their family, and all these things. And you find the suicide note saying that let not any other gynecologist be suffered like what she had undergone. So that's a unique case. I think that is why the medical fraternity went about trying to project it in a higher way and try to dedicate most of their good work for her cause that she had done for the medical fraternity and the gynecologists. Of course, no one has got the right to take their own life, that too quoting that for the sake of the professional, but she took that bold decision, but a bad decision on that way.
Yes.
That is.
So have fearless practice. I always tell, my teacher used to tell that if you do not perforate a single uterus, you are not doing enough MTPs. I am telling you, if you do not receive a single notice, you are not having enough practice. Please increase your practice. So be bold, and if even suicidal idea comes into your mind, don't hang yourself like her. Jump from the height on the person who is harassing you. At least kill him also. Right? So don't die alone. Kill one and then you die. So don't take such drastic steps. Be bold, be firm. Nothing is going to happen to you unless something is very serious, right? Otherwise, and still you will get so much time. We have so many processes. Nobody is going to put you behind the bar immediately. They may arrest you. A police arrest, police custody can happen. Like they will take you into police custody. But either you will get the bail because you are a doctor. It is easy to get the bail. Or it will be a bailable offense itself, and policeman himself will give you the bail. So don't worry. And if you don't have any history of crime, you will get the bail. So don't worry about that. It is 1 or 2 days, no problem. Right? Don't worry. And don't think about all bad things. Jail is also a good place. I always say this also. If you have to go to jail, do not take it as negatively. It is good thing. They will give you clothes. They will give you work. They will give you money. They will give you food.
Timely food.
Yes, they will give you food. You get to see your spouse 1 in 15 days. And you will have Z security. Anywhere you go, they will present you in the court. There will be 4 police officers with AK-20, AK-27, AK-47. Right? Where do you get such security? So it's a privilege to go there. Don't worry. Gandhiji was in jail. Pandit Nehru was in jail. Oh, everybody had gone to jail. Don't worry. Right? So don't fear that also. Remove all these fears. It is because of fear we are taking such drastic steps. Right? Don't keep such fears. Have fear-free practice. That's it. Right? Thank you.
And mob violence is not an issue in the state of Tamil Nadu. We have Act 48 of 2008, and if the mob is going to attack you, we always say have a CCTV so that you have a recording who does all the violence. Trying to escape is an easy issue, but see to that the person who indulges in all these things are taken to task by the law. And CCTV is a very, very important one in all your reception. And if you have it, second state in our country was Tamil Nadu to implement the Medical Establishment Protection Bill 48 of 2008. It's almost 15 years of experience. With the 15 years of experience, it has slowly coming down, but randomly in a very big level. But then we have the law to take care of the people.
Yes, the problem is doctors are not filing FIR. That's it. Just call the police, file an FIR, be courageous. Right? Always file an FIR. If some patient is even abusing you, threatening you, file an FIR. Even I have filed an FIR for defamation. They have used defamatory word in the consumer complaint. And I have filed a criminal complaint against that patient for using defamatory words. I said you remain stick to the problem which has happened. Don't write doctor is idiot and this and that. This is defamation. And now patient is coming to me that you take back this case, we will take back the consumer case. I said consumer any which way I am going to win. I will see that you will go to jail for defamation of my client. So please be firm, be sure about the law and always show some courage. Right? Don't live in this fears. Fear is everywhere. It is in our mind actually. That should not be there. That's it.
Sure, sir. Thank you.
Thank you.
Thank you, sir. Thank you very much for this wonderful session, for clearing all the doubts and encouraging people to be courageous. That is more important, and stay together. That is more important. And stay with your associations and be a part of the society so that your colleagues can help you. Thank you.
Thank you, sir. So, we'll have the felicitation. May I please invite Dr. Sharda Chandrasekhar ma'am to felicitate Dr. Hitesh Bhatt, sir. May I please invite Dr. Ashok Kumar, sir, to felicitate our chairpersons. Thank you.
The quiz session, we are planning to do it online a day after tomorrow. We'll formulate an online platform to run the quiz, and definitely we wanted to give the iPad as the prize to the quiz winner. So because the participants are less here, we wanted to do it in an online platform. We'll do it for the, if they're having a group photo. Thank you. I think Hitesh sir patiently waited despite her schedule.